When an individual is convicted in federal court after a trial, or a plea for that matter, they have 14 days to file a notice of appeal. The record is compiled, the transcripts are prepared, and the case goes to the appropriate Circuit Court of Appeals. Our firm is unique in that we have lawyers who are members of every single Circuit Court of Appeals in the country. We've represented clients nationwide in federal appeals. Once the Circuit Court of Appeals has the case, they assign a briefing schedule, and we will have then a date where we will file a brief in support of our client's position. The government will file their brief, usually around 30 days later, and then we have another time frame to file a final response. We also request oral argument on the appeal, and that's at the discretion of the court. And again, we go nationwide for oral argument. I've argued in D.C. and Richmond, Virginia, Cincinnati, Ohio, Portland, Oregon, all across the country, where the lawyer, not the client, but the lawyer has the opportunity to go to the Court of Appeals and argue in front of the 3-judge panel that is assigned to their case and address specific questions that the judges have about the facts and the law involved in the case. Once that's done, then the case waits for the decision by the 3-judge panel. Individuals also have the opportunity for federal habeas, and sometimes clients consider that as part of the appeal process because it is the next step. And that is a 1-year time limit, that after the appeal is complete, an individual has 1 year to file for federal habeas or 2255, as we call it, after the statute for which it's named. In habeas, federal individuals convicted of federal crimes have the opportunity to raise the issue of ineffective assistance of counsel. So any mistakes that their attorney made at trial can be raised through the 2255 process rather than the appeal. That's litigated back in the district court, but then can also make its way through the Court of Appeals again if necessary.